Today I'll be discussing on the role of the criminal courts in India. As we know that there are two types of courts, that is civil and the criminal courts, and both functioning is different. Now see, the administration of criminal justice is carried out by whom? It's through the magistrate court and the session courts. The IPC, together with other penal laws, it constitutes India's substantive criminal law. The IPC draws inspiration from the English criminal law. However, it cannot be self-operative. As a sequel to the IPC, a CRPC 1861 was enacted. An 1861 code was repealed, after which a new code of criminal procedure 1974 was enacted to carry out the process of the administration and enforcement of the substantive criminal law. The CRPC also controls and regulates the working of the machinery set up for the investigation and trial of the offences. In addition to the CRPC, the Indian Evidence Act of 1872 was enacted to guide the process of investigation and trial. Now, what are the categories of the criminal courts in India? There are various categories of criminal courts. First is the Court of Session. As I have told you that they should be administered. As in the first slide, you can see that the administration of the criminal justice is carried out by the magistrate court and the session court. So, first category of criminal courts in India is the Court of Session. We know that as per section 9 of CRPC, it tells that the court is established, this session court is established by the state government for every session division. The court is presided over by a judge which is appointed by the High Court of that particular state. The High Court may also appoint the additional session judge and the assistant session judges in this court. It has the power to impose any sentence including capital punishment. Now, the next category of courts is the Court of Judicial Magistrates. Section 11 of CRPC states that in every district, not being a metropolitan area, there shall be at least the Court of Judicial Magistrate of the first class and of the second class, and also at such places as the state government may, after consultation with the High Court, by notification specify. It may specify there should be the courts of judicial magistrate of the first class and also the second class. The courts of judicial magistrate of the first class are the second lowest level of the criminal court structure in India, because the first is the session court. Now, according to section 15 of the CRPC, a judicial magistrate is under the general control of the session judge and is subordinate to the judicial magistrate, chief judicial magistrate. In terms of section 29 of the CRPC, a judicial magistrate of the first class may pass a sentence of imprisonment for a term not exceeding 3 years or a fine not exceeding 5,000 rupees. Now you see the chief judicial magistrate and the additional chief judicial magistrates. In every district, not being a metropolitan area, the High Court shall appoint a judicial magistrate of the first class to be the chief judicial magistrate. A chief judicial magistrate may impose a sentence except that sentence or imprisonment for a life or imprisonment for a life exceeding 7 years. The Chief Judicial Magistrate, that is the CJM, it shall be subordinate to the Session Judge, and every other judicial magistrate shall, subject to the general control of the Session Judge, be subordinate to the CJM. Now, the next category is the Metropolitan Magistrates. The Metropolitan Magistrates were created by Section 16 of the CRPC. The Court of Chief CMM and those of the additional CMM were created, but that is the Chief Metropolitan Magistrate, were created by the Section 17 of the Code. Section 18 of the Code also provided for special metropolitan magistrates. The towns, now we know which area is considered to be a metropolitan area. The towns which are having the population of more than 1 million should be declared as the metropolitan area. The metropolitan magistrate is under the whose control? They are under the general control of the session judge and is subordinate to the chief metropolitan magistrates. The next category is the executive magistrates. In every district and in every metropolitan area, the state government may appoint as many persons as it thinks fit to be executive magistrates and shall appoint one of them to be the DM, that is the district magistrates. The state government may appoint any executive magistrates to be an additional district magistrate, and such magistrate shall have such of the powers of the district magistrate under this 179 code or under any other law for the time being in force as may be directed by the state government. Now, the next category is the special executive magistrates. Under section 21 of the CRPC, the state government may appoint executive magistrates to be known as special executive magistrates for particular areas or for the performance of particular functions and confer on such special executive magistrates such of the powers as are conferable under this codes on executive magistrates as it may deem fit. Now, the court at the lowest level is called the judicial magistrate of the second class, and the power is that it can try cases if the offence is punishable with imprisonment for a term not exceeding 1 year or with fine not exceeding 5,000 rupees or with both. The first class magistrate is competent to try offences punishable with imprisonment for a term not exceeding 3 years or with fine of 10,000 rupees. So you can see that these are the categories of the criminal courts in India,